How is everybody today? First day of autumn, and we're at 80 degrees. I'll take it. I don't know about everybody else. I'll take it. So welcome. Thank you for coming. As has been typical over the past 2 years, I am going to start by giving you guys an overview of things that have happened, some of which you already know. Many of you were at the hearings. And then I will answer any questions anybody has, and as usual, I will answer them as well as I can, keeping in mind that we are engaged in litigation, so if I can't answer it for that reason, I will tell you, but to the extent that I can answer your question, I will. And if I can't answer it because I don't have the information, then I will get back to you on that, which actually at the last meeting there were a couple of questions, and I have some follow-up responses to those tonight to give you. So where we are right now, many of you probably know the most significant thing that happened over since we last were together is Judge Smith, who's the judge overseeing the federal litigation case, heard 3 hearings, or held 3 hearings. One was on the final approval of the settlement with Charter Care Foundation, which would result in $4.5 million into the plan. The next was a hearing on final approval of the Charter Care Community Board, Old St. Joe's, Old Roger Williams settlement, which the cash portion of that is no less than 11.2, I believe the number is, 11.1, 11.2, and I'll explain what I mean by the cash portion of that in a second. And then the third hearing was on all of the defendants' motions to dismiss the case as to them. I will start by speaking to the one that I started with, which was the settlement of Charter Care Foundation. Although we do not yet have an order by the judge on that settlement, the judge did indicate from the bench, and the notes that were entered in the federal system indicate that that settlement was, in fact, approved. So the judge did give final approval of that settlement. I do want to remind everybody, though, that settlement involved the charitable assets that went to Charter Care Foundation and are being held by the Rhode Island Foundation. And so what we have to do is, there was an order by Judge Stern in Superior Court that was the vehicle for those funds to move over to the Rhode Island Foundation. In light of the settlement, we need to ask Judge Stern now to modify his order to allow for that money to come into the plan. So we got the final approval from the federal court, but we've got one more step on this one because of the fact that there was an order of the Superior Court directing it to go someplace very specific. Once we get the final approval from Judge Smith, the official approval from Judge Smith, which will be an order, then we will be presenting a petition to Judge Stern. We have already had discussions with the Rhode Island Attorney General, who would be the party who would have to come in and provide input to the court as to whether or not the modification was appropriate. And although I cannot speak for the Attorney General's office, and they have not yet taken an official position, it's my understanding that we will walk in front of Judge Stern and be in consent as to how that's going to be dealt with. So that's something we have to do, but I don't foresee any problems with doing that, and that will be the first settlement likely that will have money coming back into the plan. The next settlement was the settlement with Charter Care Community Board and the old hospitals. I'll call it the old Fatima, Old Roger Williams. The cash portion of that settlement is slightly over 11 million, or it's supposed to be no less than 11 million. I actually anticipate that the cash portion will, if it's approved, will come in at approximately 12, maybe a little bit more than $12 million. The reason why I say the cash portion is because in addition to cash, there was a pledge of other assets as well. There's an escrow being held by one of the state departments, Rhode Island state departments, for workers' compensation claims. There's also the 15% interest in the joint venture that in 2014 had a value of approximately $16 million that we're dealing with right now. And there are other claims as well that are going to be assigned to the estate, some which may have some value, some which we may find have no value, but we took an assignment of them because if there is value there, we wanted to get it. So although the settlement cash portion is about $12 million, there could be substantially more money coming into the plan, or those assignments could turn out to be valueless. So that's why I'm focusing just on the cash portion at this point. We'll have to investigate and liquidate those other claims or those other assignments in order to determine what's coming into the plan. On that one, those who were at the hearing and who have been kind of paying more close attention to it, there was a challenge to that settlement initially by the defendants. Quite frankly, they were alleging that the settlement was too good for the plan. And as a result, they were saying that in order to reach a settlement like that, I had to have done something wrong, along with the attorneys for the old hospitals, the old Heritage hospitals. So there was some discovery. My deposition was taken, the other attorney's deposition was taken, to see if there was any type of collusion that took place between myself and the other attorney to determine whether or not that settlement was in fact too good to be true. Again, although the judge has not issued an order on either the approval or that issue, the judge did indicate from the bench that he did not believe that there was any improper conduct that took place, that the settlement, although it was a very good settlement, was a fair settlement and a reasonable settlement. So I am hopeful. Again, the judge didn't indicate from the bench the way he did with the Charter Care Foundation one that he would approve it, but I'm hopeful that he will, and that money will come in short order as well. In addition, in connection with those two settlements, Wistow, Sheen and Lovely, Max Wistow's office with Steve Sheen and Benjamin Letzum, I entered into an engagement with them so that they could represent me as special counsel, as well as to represent the class in the lawsuit in federal court. That engagement letter called for them to get a percentage of compensation based on recovery. Judge Smith has engaged Attorney Deming Sherman to act as a special master. And what he's going to do is he's going to investigate the appropriateness of the contingency fee that Wistow, Sheen and Lovely would purport to get under the engagement. He's going to issue a report. We actually have a meeting, I believe it's next week? We have a meeting with the special master to kind of discuss what he's going to do. And ultimately, he's going to make a recommendation to Judge Smith on Wistow, Sheen and Lovely's fees, and those will get paid from the settlement proceeds before the money goes into the plan. That's the two settlements, which obviously are the two most important things because those result in substantial money into the plan. And then there was the motions to dismiss. Those of you who were at the hearing might have been a little confused as to what happened at the motions to dismiss, because we held, Judge Smith held approximately 2 hours worth of hearings on motions to dismiss, and then at one point he did cut the hearings off and indicated that he was not going to rule on the motions to dismiss. I am here to tell you that that is as good of a result as we could have get other than a denial of those motions. What that means is that the judge said he's not addressing the issues. He rendered all the issues moot, meaning that he's not going to be issuing a decision on them. It means that all the defendants are still in the case and all counts in the complaint are still alive. And what he then directed the parties is to come together and agree to a discovery schedule, which is a schedule by which the parties will start to exchange information. Depositions, interrogatories, documents, things of that nature. And if we can't agree to a schedule, the judge said present competing schedules and I will determine the schedule based on those competing schedules. So that's where we stand right now. The motions to dismiss are over. Nobody was let out of the case. No counts were dismissed out of the case. And we're going to proceed down with discovery. Many of you might be asking and saying, well, I thought you guys did a whole lot of document collection prior to the litigation being filed. And I did. I did a lot of document collection pursuant to Judge Stern's order. We collected over 1 million pages worth of information from all the parties. But that was not part of discovery. That was part of the investigation to see if anybody and who, if we found somebody, should be responsible for what happened to the plan. Discovery, now that we've got many of those records, our document requests may be smaller than they otherwise would have been, but we still need to take depositions and ask interrogatories and get admissions and things of that nature. So that's the process we are at right now. I am hopeful, as you guys know, we did engage in a mediation, a couple of days of mediation a few months back. I believe it was back in May. Does that sound about right? May or June. And it was, although that didn't result in any resolution of the issues among the parties, it seemed to be clear that we needed to get past the motions to dismiss. People were not, and this is not just for the defendants in this case, this is typical for defendants in litigation. They're not really interested in resolving something if they think they might get out of the case for free anyway. Well, now we're past the motions to dismiss. Nobody's out of the case. And so now I am hopeful, I have no way of knowing, but I'm hopeful that if the parties decide to re-engage in mediation, that it might result in something more fruitful this time. So that's where we stand in the case. The next thing you're probably going to see is an approval of one or both settlements by Judge Smith. If it's the CCF, Charter Care Foundation settlement, you will see a motion filed in front of Judge Stern to modify what's called a Cypre order. And then we'll have the hearing on that. And once, if and when that's approved, the money will flow into the plan from that settlement. And the CCCB one, similarly, the cash portion will flow if that settlement is approved within a short period of time afterwards. Okay. With regard to status, I think that's really where we are right now. I will, at the last meeting, we had 2 questions asked. One question that I still don't have a clear answer on, but I am going to give you an update on what I do have, is how many participants have passed since this proceeding began in August of 2017. The parties that have that information have to, I guess they have to, they've got to whittle it down more because the number that they have is not accurate to answer that question. So I've asked them to go back and to refine was the word I was thinking of. They got to refine their response to me because the response that they gave me was not accurate to answer that question. I hope to have that response to you, and I should have that response to you by the next time that we meet. But as of right now, I do not have that answer. Clearly, there have been people who have passed. I have been made aware from many of you of your fellow pension holders that have passed during this process. So it's certainly not something that we are unaware of, and that does not cause pain for everybody in this room, as well as their families. But I do not have that number right now. The other question that was asked was how much time do we have with the current assets of the plan for this plan to live on? Keeping in mind a couple of things, that that answer is contingent on a number of variables. It's contingent on what happens with the market. It's contingent on whether or not these settlements are approved and that money comes into the plan or not. It's contingent on how many people elect to collect benefits between now and next year, or the year after that. It's contingent on how many people stop receiving benefits over that period of time as well, and how many of them have beneficiaries that are going to be collecting versus not collecting anything. So there are a number of factors that go in. So when I give you the answer I'm about to give you, keep in mind, certain assumptions are made. One, that the rate of return on our investments is going to average about 5% per year. It may be higher, it may be lower, but I have to make an assumption in order to get that number so I can give you a number. So the assumption is 5%. It also assumes no more money coming into the plan, so it does not assume that any of the money on these settlements is coming in. And it also assumes a benefit payment of approximately, is it about 12 million a year? 11.5 to 12 million a year?
Starts out in the high
starts out in the high 11s and then it ticks down into the 10s as the years go on. With that information, keeping in mind that we have no way of, we don't have a crystal ball, so we don't know how much of this information is going to be accurate, we're about 6.5 years away from the plan not having any money, assuming no money coming in and assuming all of those variables. Keep in mind, when I was standing in front of you back in September, October of 2017, I think I was telling you it might have been about a 7-year runway. So the good news is that we've gone 2 years further and we haven't changed the runway from today, so we've actually captured a couple of years. And the other good news is that 2 years ago when I gave you the 7-year number, we were nowhere near a settlement with anybody. And now there's the potential of getting, at least from a cash portion, or hopefully before the end of the year, certainly within the next 8 to 10 months, another, call it $15–16 million into the plan, with more to potentially come depending on the assignment of those other assets. So we're in a much better position in that sense than we were 2 years ago. The market has performed well for us in the 2 years that we've been together. The market has been a little more volatile. It hasn't been as cooperative recently, but it still isn't bad. And so we're doing okay with what we've got. Obviously, we need more. The more money that goes into the plan, the more that money can work for us, and the more that it can extend that runway. Obviously, that's what I'm here to do. So that's where we stand right now.
Excuse me, the diocese lawyer, he said in the year 2006 and 7 there was an abundance of money. And then in the year 2009, they were broke. We also were told on the floors, not from the nursing supervisors, but from administration, that they would go around to the managers and say, Fran, what would you rather do? Would you rather have money now, or would you rather wait for your pension? So, of course, everybody was doing good. They'd rather wait. But but did anybody pick up on that? I didn't see anybody addressing that. What happened between 2006 and 2009?
Well, I did address that in the complaint. That stands for part of the counts that we have in the complaints. And what I will tell you is that I'm not going to take the characterizations of the diocese attorney. I'm just going to give you the facts as I know them. The last money that went into this plan was in September of 2008. After September of 2008, the next time that money came into the plan was the $14 million that came in as part of the Prospect sale in 2014. What that $14 million was, I believe they intended it to do, was to take the money that should have gone in 09, 10, 11, 12, and 13, and basically put it in. So over that period of time, they should have put in $14 million. They put in nothing.
We were told on the floor that the bishop stopped putting it in 2008.
I'm
just saying.
No, and I'm going to, because of the litigation, I'm not going to say whether or not it was or was not the diocese.
Everybody here.
No, but I will say to you that it is an accurate statement to say that whoever was responsible to put money in, nobody did after 2008 until 2014. And what the status of the plan was in terms of funding in 07 and before, it might have been properly funded at that time. I'm not going to use the term fully funded because it was not fully funded. It might have been properly funded at that time, but once September of 2008 passed, it was no longer properly funded. And the 2014 money was the last slog of cash, and as you all know, since 2014, there hasn't been any money that's gone into this plan. So when you go from 08 to 2019, where we are today, there was $14 million that went into the plan over the span of that 11 years.
So in other words, has the diocese put any money in?
No. Not since nobody other than Prospect has put money in since 2008. And Prospect put that money in, the $14 million, as part of their sale as part of their purchase price. That was a factor of their purchase price. I keep hitting this, I'm sorry.
So you say we have approximately 6.5 years
Assuming,
at this point in time?
correct, and keep in mind that that is an estimate based on a number of variables that may or may not come true.
But have you figured out when we get this 12 million, how much time we would have?
I have not figured that out yet because I want to get it in before, I don't want to count my chickens before they hatch. Once we get money in, excuse me, we'll put whatever that amount is into the plan, and I will ask to recalculate that and see what it changes. And then if the next batch of money comes in, I'm going to ask them to recalculate based on that, not only because you all deserve to know, but clearly as I'm sitting here trying to make sure that the pension stays alive for you, I need to know what the time frame is and how much this is affecting that time frame.
Is there any news on the put option?
The only news on the put option is we were supposed to, originally the put needed to be, or the time frame to start the CCCB or my exercise of the put was originally in June. We pushed it to September. And then on the eve of the hearing on September, in an effort to try to resolve it so that that issue could be resolved more quickly, we pushed it another 30 days to October 20th. The reason being, just so everybody knows, one of the things that was assigned to me was that 15% interest. The put is an option to force Prospect to buy that 15% interest from CCCB from me, turn it into cash. Obviously, I need to assess whether or not that's a good decision to do. Back in 2014, there was a document that said that that 15% was worth approximately $16 million. If I found out today that it was worth $3 million, I'd have to think long and hard as to whether or not I was going to liquidate that, because I'd need to know why it had dropped so much, and I'd need to know what the, no pun intended, what the prospect was for it to go up. If I find out that the value is similar to what it was in 14 or greater, then obviously it may make my decision a little bit different and easier in terms of exercising that put. We've got 90 days to exercise it once the time frame starts. So obviously this plan needs cash, but I don't want to just liquidate for the sake of liquidating, and I want to make sure that Prospect has been doing what they're supposed to be doing, and the hospital's value, which would result in value to the plan if we exercise the put, is appropriate. So I'm doing an evaluation now along with CCCB, because they're the ones who actually still hold it, to find out what exactly that value is. Once we finalize that, and we've been partially, what we've been fighting about with Prospect is getting documents so that we can properly evaluate that value. They've given us some of the documents, but not all of the documents. And part of the reason to push it from September to October was because there was an agreement that we would get additional documentation, but it would take a little bit longer than they anticipated, and it was going to go past the September 20th date. So that's where we stand right now. I've gotten a preliminary valuation, but that is a preliminary valuation that is not based on all the information I need to get a proper one.
Where do we stand with the potential moving the suit to Delaware?
That, as of right now, and I'm assuming nothing was entered in the docket over the past couple of days from Judge Stern. Judge Stern still has not entered an order on that. What I could tell you is that both Prospect and myself submitted competing orders. Shockingly, we saw the result of that hearing in different ways. So we submitted competing orders, and when competing orders are submitted, the judge does one of two things. The judge either chooses one of the orders that he believes accurately reflects what he decided, or he fashions his own order to accurately reflect it. As of right now, he has not entered an order. Until he does, Prospect can't do anything, but that may be coming any day now. So the judge could have entered it at the end of the day today, and we just haven't seen it yet. But as of right now, there has been nothing filed in Delaware. I will say as well if I exercise the put, which means if I tell Prospect, I want you to pay me for that 15% interest because we believe the value is here, and we go through that process, that is an issue that would be going to Delaware. However, that would probably stop it from going to Delaware. The reason I say that is because their argument, Prospect's argument, is that CCCB doesn't have the right to transfer the 15% interest to me. But if we liquidate it, if we turn it into cash, that's not transferring the interest to me, that's transferring cash to me, and that's a different story. And there's no argument that that's an improper exercise by CCCB. So that would take at least one part of their argument away. They would still have their argument that the old hospitals need to indemnify them, which means pay their legal fees for this fight. But that's an issue that would have to get resolved, and if they choose to bring that down to Delaware, they choose to bring it down to Delaware.
If we get the infusion of another 15, 16 million, that would extend hopefully the 6.5 years to 8 or possibly more. So probably around 2027, we're out of money. What happens then? I have down PBGC. Okay. Where do we stand with that? Where do we stand with ERISA? So there is some back payment of premiums. So are we all caught up in back premiums, and we have ongoing premiums to ERISA to make us eligible for PBGC?
Okay, so that, nope, that's a lot of stuff. That's a loaded question, and that is the crux of a lot of the arguments right now among the attorneys.
For 8 years, a lot of us won't be alive anymore.
Right, well,
That makes all that.
I will tell you one way or another, this is going to be resolved, God willing, before 8 years is up. I'm going to start answering in the way where I can tell you the things I know, and then I'm going to start telling you the things that could potentially happen, but we have no idea right now. So as far as the plan is concerned, obviously in the litigation we have alleged that this was an ERISA plan as early as 08, 09. And then we argue in the complaint that as the years went on after that, it became more compelling that this was an ERISA plan. It was not, should not have been treated like a church plan, but rather was in fact an ERISA plan. As far as I am concerned, that's the arguments for the lawsuit. The judge is going to determine who's right on that, who's wrong on that, and the parties are going to argue. When I became receiver, it clearly was no longer a church plan. Nobody will tell you that I am in a religious organization, nor is the court. So it ceased being a church plan on the day that I was appointed receiver, at the very least. I filed an election, as many of you know, as maybe all of you know, I filed an election to be covered under ERISA in April of 2019, and I asked that that coverage be elected or be retroactive 2 years prior to April of 2017. That's as far back as I could go. So the federal law only allows you to go back 2 years on the retro application. What that means is now is that this plan is covered by ERISA and is required to comply with ERISA. One of the main things that that means is that a church plan, when they have their valuation done each year, the actuary comes forward and says, we recommend that you put X dollars into the plan this year to fund it properly. It's a recommendation, not a requirement. Under ERISA, it is, this is what you are required to put in this year to properly fund the plan. Obviously, we've got no income coming in other than what we may get on settlements. For the 2 years that we have had valuations done by the actuaries, the required payment is approximately $10 million per year for each of those years. I can tell, and I think I told you at the last meeting, or it might have been the meeting before, I made demand upon all of the defendants to pay that $20 million to me so I could meet the ERISA obligations. It should be a shock to nobody that I didn't receive a check from anybody. But I at least made the demand. So we are covered by ERISA right now as a result of the voluntary election. The reason I did that is there is an argument, as I've said, we have asserted, I have asserted, that the plan has been an ERISA plan for some time now. It has not been a church plan. However, I could be wrong. So in the event that I'm wrong, church plans are allowed to voluntarily elect to be covered under ERISA. You are exempt unless you ask to be covered. So that's what I did. So to remove any doubt, I said we are now an ERISA plan now. That resulted in us paying a premium to the PBGC, which is similar to an insurer. The best analogy would be the FDIC that insures bank deposits. That premium was approximately $1.5 million. It's calculated based on the amount of plan assets that are currently in the plan. And that would presume, and if you listen to the attorneys for the defendants, they say, oh, okay, you've elected, you've paid a premium, you're covered. Unfortunately, the PBGC doesn't see it that way right now. All the communication I've had with the PBGC thus far, and they have provided us written communication, and I think I told you guys this at a meeting in the past, is a question came up because the defendant said, now that you've elected, you don't have a right to sue us. You don't have a right to pursue any of this stuff. That's for the PBGC to do, not for you to do. We asked the PBGC. To my surprise, the PBGC responded, I think, in 24 hours with a written letter to say, no, in fact, keep doing what you're doing. It's your obligation to do it until we make a determination. You have an obligation to do whatever you can to recoup and recover as much money for this plan as is possible. And the unspoken piece of that letter is they do not have a time frame to make their decision as to what they're going to do. There's nothing in their regulations that requires them to do it within any specific period of time. So we are consistently sending them every single pleading that is filed in state and federal court. We are keeping in contact with them continuously and regularly because I want to make sure that all three, they, the IRS, and the Department of Labor are fully aware of everything that I'm doing and everything that's going on here, both in the federal court as well as the state court. But as of right now, PBGC, which is the insurer, has not taken a position as to whether or not they are going to insure this plan. And if they do, there will be then a question as to at what level. Because let's say they come tomorrow and say, okay, we've determined, or somebody told us that we have to, you've only paid one premium, and so we don't have to cover the full amount that we're required, we can cover some lesser amount. There's a number of arguments that can be made. The most important thing for all of you to take away from this is that what we are doing here and what has happened here, there is no precedent for. PBGC hasn't dealt with this circumstance before. So there's no way for us to go and look and say, okay, when this has happened in the past, PBGC did this or they didn't do this. The expert, many of you know I retained a couple of experts to assist and consult with me. One of them is a gentleman down in Washington, D.C., who was in the PBGC for 19 years. And in the latter part of that 19, I think for about 7 years, he served as their general counsel. He is telling me that this has never been, this circumstance has never happened with the PBGC. So, in essence, your guess is as good as mine as to what the PBGC is going to do with this. So while technically, because of the election, we are covered under ERISA, even if our arguments are correct that it was ERISA well before this, we are covered under ERISA now. I will continue to make my premium payments to the PBGC each year as I'm required to do. But what that means in terms of the protection of this plan at this point, that is an issue that none of the attorneys agree on what will happen, and the PBGC has given us no insight. How about that?
I'm going to try asking you a question I asked a couple months ago. Where is that money coming from?
That money is coming from the plan. So the premium to pay the PBGC, that annual premium, that money is coming directly out of the plan. The contributions, obviously, the required contribution cannot come from the plan. That would be taking money from the left pocket, putting it into the right. That has to come from an outside source. And other than...
The diocese and whatever.
Whoever,
The other 12 people.
correct, wherever we can get the money from, that will be the source of those funds. But keep in mind, we're 2 years, we're 20 million now in required contributions that haven't been made. We're going to have to do another evaluation as of June of 2020, and that's going to result in another recommended contribution, which will likely be in the same neighborhood and magnitude in terms of value.
Part of that question, when you talk about these out-of-court settlements and we're waiting for 4.5 and 11 million, where do the lawyers' fees set come in there? Do they come out of that money?
Are you talking about Wistow, Sheen, and Lovely, or are you talking about anybody else?
Our lawyers.
The only lawyers that are going to be getting paid, and I'm going to call it because it is what it is, off the top, will be Wistow, Sheen, and Lovely. They are on a contingency, which means they get a percentage of that. Judge Smith asked for a special master to be appointed to determine if that percentage is fair and reasonable. And that special master has the ability to not only review it, but recommend to Judge Smith that it should be less. It won't go higher than the percentage that was agreed to, but it could go lower. And that money would come off the top. So just to use a round number, because I'm a lawyer, not an accountant, if it's $4 million in the CCF settlement and the contingency is 25%, the net to the plan would be $3 million, if the fee is approved. Okay.
Why, once the judge finally gives the okay for those funds, does it take 8 to 10 months to get the money into the plan?
Well, first of all, part of that is because I don't know when the judge is going to issue the order. So the order could get issued in a month, it could get issued in 5 or 6. So I have to assume, because it's part of occupational hazard, I've got to assume the worst case scenario and hope for the best. The other thing is that there is a mechanism to get that money over. So under the settlement agreement, there's time for the party that we settled with to get us the money. So, because they can't just snap their fingers. For example, the CCCB money is all invested. So they would have to liquidate those investments or find a way to assign those investments over to me. And that could take a little bit of time. I use the time frame 8 months or so as really an outside, and I hope a very liberal estimate of what it's going to be, because I think it'll be much sooner. It's my hope that both settlements will be approved and funded before the end of the year. But I don't want to make that promise because I don't know, I don't control when the judge issues the decision.
In the complaint, did Max ask for attorney's fees to be paid by defendants?
I believe we did.
And if in fact some attorney's fees are awarded, would that also be deducted from the percentage that he's entitled to?
It would either be deducted from the percentage he's entitled to, or it would be, it would be deducted from the percentage that he would be entitled to. I will say this as well, before we started the litigation, Wistow, Sheen, and Lovely was billing and was getting paid on an hourly basis. So from the time in October of 17 right up until June of 18, they were getting paid hourly. They were not required to under the engagement, but they have agreed to basically credit whatever they get from these settlements, that hourly amount. Again, I don't know the exact numbers, but let's say it was $500,000. If they're entitled to get $1 million from CCF, they're only going to take $500,000 because they're going to take a credit for what they've already received. Again, they were not required to do that, but that's something that they've decided to voluntarily do.
On discovery, I assume it's been too early to say, but do you think the defense will agree to the authenticity and accuracy of the documents already produced?
Oh, of what they've already produced? I sure hope so. I mean,
Theoretically, if it's tested in federal court, would it not?
theoretically, I'd find it to be very difficult to think that they would challenge the authenticity of the documents that they provided us themselves. First of all, that would require them to produce them all over again. And I'll tell you right now, 1 million pages is a lot of boxes. I don't think they want to do that. I don't see that being a problem, but I've been surprised before.
A lot of us were in that last big, long court session. Could you please explain to us what Angel was saying?
As soon as somebody explains it to me, I can explain it to you. Essentially, and I don't want to put words in their mouth, and I don't want to improperly characterize or summarize what they were saying. But what I heard them say, and what I think you might have heard Steve Sheehan get up and basically lodge a challenge back to Angel and the other defendants, is what I heard them saying is, look, the receiver has now elected to be covered under ERISA. It's now covered under ERISA. PBGC coverage is guaranteed, and so the plan is going to be saved because of PBGC. All they have to do, all the receiver has to do, is file what's called a Form 600, which is a distressed plan termination, and the PBGC will come in and they will act on it. Putting aside my disagreement with that characterization, and that my summary, simple summary of what I heard them say, we stood up, Steve Sheehan on behalf of class counsel, stood up and said, if the defendants will guarantee that, we will drop the lawsuit immediately. Guarantee us that the PBGC will come in and save this plan and save all of these pension holders' benefits, and we will back out. If you're so confident in that position, guarantee it, and we'll dismiss the lawsuit with prejudice right now. Similar to my demand to pay the amounts under ERISA, you probably won't be surprised to hear that nobody got up and said, okay, we'll guarantee that. So they didn't. They did not guarantee it. They won't guarantee it. They still say it. I had many conversations after that hearing in which that same position has been asserted to me. But as I've told you, I'm relying on the experts that I've retained down in Washington, D.C., who I have confidence in based on their knowledge and experience, and they're telling me that's not the case. There has been a recent request to get the 3 experts in the room, Angel's expert, Prospect's expert, and my expert, to see if they can come to a consensus on what they think will happen. I'm certainly not adverse to doing that if it's going to move the ball forward, but based on the lack of precedent in this, I don't see there being any consensus. So I'm happy to engage in that exercise. I just don't see it resulting in anything beneficial for us.
Wasn't Angel saying something about what their duties toward the plan had been, and basically trying to say that they did whatever they should have?
Well, an actuary, yes. And again, I don't want to, this is my summary, so it's not a characterization of what they're doing. It's my characterization of what they're saying. Is they're in essence saying we're actuaries. We don't give advice. We don't do it. We give you tell us what you want to be calculated, and we calculate it. So you ask us, how long does this plan last with 70 million in it? You tell us what you want the rate of return to be. You tell us how much money is going to go in over that period of time, when it's going to go in, and we're going to do the calculation and plug it into the formula and give you the information. So their position is all we did was give numbers. We didn't give advice. We didn't do anything. Obviously, the complaint speaks for itself that I don't agree with that position, but that's their position, is that they didn't have any responsibility because they were just data collectors and calculators.
I have received a summary plan description. Are you aware of this?
That was from me.
Oh,
That was from me.
everyone has received.
Everybody received that, and I also posted it to the website. So that is a summary plan. It was not posted. It was not posted to the website, but everybody received it. That's something that's required under ERISA to provide to all plan beneficiaries. So you each got one of those. That was something that we put together because we amended the plan. The reason we amended the plan is because I was making the election under ERISA, and the plan as it existed was not compliant with ERISA. So I amended the plan to make it compliant with ERISA, and then we had to provide you with a summary of what that plan looks like now, because it's different than what it looked like before April 2019.
Nobody had making a reference to it, so I thought I was the only one.
No, everybody got one. Everybody got one.
Did I read that amending correctly, that there's no longer like a magic 85 on taking the plan, or
Are you talking about the plan, just the summary plan description?
whatever you did to amend the plan?
Yeah.
And did that change the retirement age allowed?
I do not believe it changed the retirement age allowed in any way. It did, one of the things it absolutely did was it changed the spousal beneficiary requirement, which under the church plan, as it was treated, you could have a beneficiary of somebody who was not your spouse if you had a spouse, and you did not need your spouse's consent. Under ERISA, you cannot have a beneficiary that is not your spouse unless your spouse consents to that. So that's one thing it did change in terms of that, but it's my recollection that the early retirement and the standard retirement age stayed the same. I'll confirm that, but that's my understanding. It's been a while since I looked at it. Does anybody have any other questions?
One last question. Bottom line is, if we can prove that it wasn't a church plan and it should have been an ERISA plan, is anybody going to go to jail?
Well, I'm going to answer the question in this way. That's for the law enforcement authorities to decide, the Attorney General's office and whatnot. I am a civil receiver, and I am pursuing civil damages, which are financial damages. So to the extent that anybody has done anything that would rise to a criminal level, that is not for me to pursue or to weigh on.
Could certain parties potentially be in trouble with like the IRS and a few other federal agencies?
All I can say is I would imagine it could be possible, but I have no way of knowing whether or not that's going on here.
don't know.
Yeah. Anything's possible, especially when it comes to federal agencies. Okay. Any other questions?
So when is the rise of Providence going to be on the parade?
When they're going to be on? I'm saying, say that?
List of events directed. When are we going to close that?
Well, we are in court. The diocese, everybody, oh, you mean when are we settling with them? Well, as soon as somebody presents me with a settlement offer, I will evaluate it, and then I will negotiate it, and if it's something that I believe is beneficial for all of you, then I will present it. But as of right now, the only parties that have presented me with a settlement that I believe is reasonable and fair are Charter Care Foundation and Charter Care Community Board, St. Joe's, Roger Williams, the old hospitals. I've received no offer of settlement from any other parties. We're going to continue suing, and hopefully one way or the other, either the lawsuit results in an award or the parties see fit to advance a settlement to me, a settlement offer to me. I mean, I'll tell you that the settlement offers that I received from CCCB and CCF initially did not look anything like what we ultimately agreed to. So you can at least know that between myself and Wistoshin and Lovely, we're not taking the first offer that's given to us and signing on the line and saying, let's run with it. We're negotiating and negotiating heavily, and we're willing to walk away from the table if a negotiation is not something that we think is fair under the circumstances. Gotta keep trying. I know you don't have a whole lot of faith in them, but have some faith. Well, I'm like I said, I'm hoping that now that the motions to dismiss are behind us, and I will say that although we haven't talked anything substantive, I did receive a call from counsel to some of the defendants saying that they were getting together because they were discussing whether or not they would present some type of a settlement over to us. Whether or not they do that, I don't know. It hasn't happened yet. And even if they do, whether or not it's something that I would even entertain, I don't know, and I won't know until I see it. Obviously, my phone is on, Max's phone is on, and we're willing to take a call. I'll consider anything. I may not accept it, but I'll consider anything. Maybe. I know.
I'm going to ask. In one of the letters that was sent out, there was an example of like two groups, a settling group and a non-settling group. And I think they said the settling group agreed to say $100, $100,000, or whatever. The non-settling group, the judgment went against them for say $500. But they came back and said, well, you've already got 100 from the settling group. That amount would be subtracted from the judgment group. So if the settling group comes in at, say, 11 million,
Yep.
then we successfully pursue the suits against the other non-settlers, and that comes in, let's say, 15 million. Would that 11 million from the settlers be subtracted from the 15 million, yielding a net of 4 million?
You like to ask questions that I can't really answer, don't you? We've got legislation that has passed that the defendants are challenging the constitutionality of. And under Rhode Island law, as it exists without the special legislation, the contribution from other defendants would be considered in an ultimate judgment, not a settlement, but a judgment. Under the statute that we had passed, just because one party settles, whether they are 99% at fault or 1% at fault, the other parties can't say, well, they were 99% at fault and they paid 11, so we only have to pay 1% of the ultimate judgment. So that statute, though, is being challenged. The parties have raised the issue to Judge Smith in federal court that they believe that it's unconstitutional. And Judge Smith has not taken a position on that yet. I believe it is constitutional. The same legislation was passed during the DEPCO times. It was passed during the Station Night Club fire, and it was passed during 38 Studios. And I believe in the 38 Studios case, the Supreme Court addressed the constitutionality of it in that case and said that it was constitutional. Don't hold me to that, but I believe that was the decision from the Supreme Court. Our Supreme Court, the state Supreme Court. So I believe it is a constitutional statute. Doesn't mean that they can't challenge it. And until the judge rules on the constitutionality of that, the question you just asked can't be answered.
I have a burning question since that last court hearing for the motions to dismiss. How did the attorney for the diocese get away with saying that the diocese never owned St. Joseph Hillsbury?
He said it. Well, you would have to ask the diocese council as to the basis. All I can tell you is that regardless of what was said at that hearing, regardless of what was briefed with regard to those motions to dismiss, the end result is that the judge didn't accept any of the motions to dismiss, and they are all moot.
But ethically, to get the judge in line, the plaintiff below
there had,
So a long time for a pension that I said I wanted to negotiate committee, and then their excuse was always, you're a diocesan, you cannot
do that. Again, I can't speak for the basis for which the Diocese Council said anything. I'm sure that they had what they believed a reasonable basis for saying it. But I can't speak for their thought process, motivation, or rationale behind it.
They drank the bishop's Kool-Aid, that's
Maybe. Isn't that altar wine? Isn't that altar wine? Altar wine? Yeah.
As far as the paperwork, comment on that?
Well, I haven't seen it yet, and many people here have sent similar paperwork. So, as many of you have already done, if you come across paperwork that you received over the years in your time, either employed or post-employment with any of the hospitals, that seems to make a representation to you that you relied upon, that seems to be, don't worry about it, you've got this. Please provide that to us as you have been. As we go through discovery, we've already received 1 million pages, but as we go through discovery and things are produced to us, the information that you provide us will either verify what they're sending us, or it will contradict something that we're getting, and it will be helpful. So I know many of you have already done so. I don't want anybody like running up to their attic and start rummaging through decades-old boxes and breathing in all the dust and dirt. But if you come across something, by all means, if you think it might be helpful, send it along, and we appreciate it. Any other questions?
Do you want to talk about Channel 10?
Sure. So, as many of you may know, Channel 10 was actually at the federal court hearing, and I know that they interviewed not only Marilyn, but they interviewed one other of your fellow pension holders. I will tell you that they interviewed myself and Max this morning. I do not know when that piece is going to air. I don't imagine it's going to be very far into the future, but it's my understanding that they're going to take portions of what you did, and I don't speak for Parker Gavigan, so I'm just making a guess based on what I understood. Take pieces of what he spoke to you about, and he's going to take pieces of what he spoke to Max and I about, and they're going to put together a piece that they're going to be running about the pension. So that will probably be anywhere within the next week or so, I would imagine, because today we were with them, and I think that was the last piece that he needed in order to do his piece. So to the extent you watch Channel 10, look out for it. To the extent you don't, talk to your friends who do, and they can tell you when it's on.
Thank you.
Thank you. If there are no questions, drive safely, everybody. Oh, wait, I've got one question. There are no scheduled court hearings yet. I'm sorry. When did we continue the put option and the motion to compel? Do you remember? I think it's got to be before October 20th. The hearing on my request to allow me to exercise the put and CCCB's request to compel Prospect to produce documents has been continued to a date October 1st, next week. So that's the next hearing is October 1st. That's in state court in front of Judge Stern, okay, at 2 o'clock. All right? Sure. Everybody have a good night, drive safely, and enjoy the warm weather that we've been having.